back to another episode of Justice for Y'all. I'm Paul Painter, and with me as always is my partner Andrew Bowen. Andrew, how are you today?
Doing good, Paul. Good afternoon.
Good afternoon. What do we have on tap today?
Well, we're going to talk about cases that you shouldn't keep, whether that's by rejection or referring or associating someone else to work on them or work on them with you.
That's a difficult choice, on both ends of that.
You're tuned into the podcast where justice meets Southern hospitality, broadcasting directly from Savannah, Georgia, where your go-to source for all things legal. Served up with a dose of Southern charm and commitment to justice for y'all.
On both ends of that.
Well, I think every lawyer who does what we do has had a case where they look back on it and either regret taking it or regret handling it the way it was handled. You say to yourself, if I'd known then what I know now, I would have done something different.
Yeah.
So this what we're going to try to talk about how to recognize those cases sooner.
All right. Shall we start with the ones that you just don't want? We'll start with what probably the easiest evaluation, though it should be easy. It's not easy, and that's your case list starts getting a little low. The phone hadn't been ringing, and then the phone rings with a case that you know has red flags going everywhere. It's like a hurricane coming in.
Yeah. And there are the obvious cases that just aren't a case. The person wasn't hurt or the person's calling in because they were in a wreck, but it turns out they're at fault, or, they want to sue somebody because a deer ran in front of their car. We've actually had that phone call. And that's not really what we're talking about. Obviously you're going to reject those cases.
Right.
But there are other cases where either the liability is going to be a real fight, but maybe the damages are big enough that you think it might be worth it, and it may be. Or, the most common thing I think we come across with cases that otherwise may be pretty good cases are where the plaintiff just isn't a good plaintiff.
No. And you can usually tell pretty quickly. I mean, you've been doing it long enough, you can just sort of tell. With the liability, let's talk about that's a little bit more concrete. You get a case in that's got minimal damages. Got damages, but nothing catastrophic. It's not going to be even six-figure case. And you get the rec report, and your guy's or woman's found at fault. Your client, potential client, is saying, "Oh no, they got it all wrong. This is what happened." That is a trap.
Yeah.
Right. Because maybe so, and there are cases where the injuries are bad enough to where it's worth seeing if you can kind of overcome that burden. But if you've got a case that you're looking at because this is the type of case, if you have liability, it should settle quickly. Are you willing to get into protracted litigation over a $30,000 car wreck case with contested liability? And the answer to that question should be no.
Right.
I mean, that unless you're just brand new in the market and you just got to take what you can get and you want to go litigate cases, that is not a good use of your time.
Yeah. At the end of the day, looking at the hours spent on a case like that, you're going to lose money.
Yeah. Well, I'll go to the second type. The second phase of that is the difficult client. Lots of ways that can present itself.
Yeah. Well, as you know, one of our sort of our central core values as a firm is to get money justice for good people ASAP, as quickly as possible. Yeah. But a key component of that is for good people. Especially if you're going to take a case to trial, having a good client can be the ultimate difference between a disappointing verdict and a home run verdict.
The most important factor, I think.
Yeah. And then there are the clients who call up, who you quickly learn are going to be badgering your staff, rude to your staff, and that's a huge red flag.
Yeah, well, we just reject those. I mean, you can't deal with that. Life's too short for.
Yeah, and we've turned down some what should otherwise be pretty good cases because the client was just a jerk.
Yeah.
We really love and respect our staff here, and we know that they do a good job. We know they care about their clients and their cases, and so 9 times out of 10, and in fact I can't remember when that 10th one was. We are going to have their back when a client is angry and rude. And
you got to be able to tell the difference too, because some of these people are going through the worst time of their life, right? So when you're under stress and you're not working, the bills are piling up, you're in pain. people are not going to be at their best. So there's a difference between somebody who is frustrated and is acting out and somebody who's just a jerk.
Mm-hmm.
And, you know, usually they have one time and we talk to them and say, listen, you can't do that. The people who are just in a bad situation will just say, I'm really sorry, you're right. I apologize to you.
Yeah.
Some people just don't hear that, and that's just who they are, and it was who they were before they got in a wreck or whatever.
Yeah. And then there's another type of client that is a huge red flag, and that's the client who has got their case totally figured out. They know exactly what the causes of action are. They know exactly what the strategy is going to be, and they're going to tell you how to do it. And these days, you're seeing it with people getting into AI. We had one recently where, you know, it was a case that's probably not a case, but the client contacted us with this huge write-up of why it was a case and how there were federal civil rights claims and claims against the municipality.
Just clearly ChatGPT wrote all this.
Right. And, you know, presented us with a very clear statement of what the, you know, tens of millions of dollars of damages were, and insisted that the damages, that was a floor and damages were rising. And, you know, we took a look at that and said, this client is just going to be a nightmare. We don't even want to take this case.
I had a professor in law school who was adjunct professor, he was practicing law. He was talking about the business and the practice of law, and he goes, you know, you're going to get somebody, you're going to have a situation like this happen to you. I had a client, potential client who came in and said, I got this matter, you know, and I said, well, why did you choose me? And he said, God told me to come see you. And he goes, you always want to reject that client because when it comes time, he'd expect God to pay you fees too. That's kind of like the AI.
Yeah.
You know, if you get a client like that, they're already listening to AI more than they're going to listen to you.
Yeah.
And so I've got no problem with a client going and doing research and looking at AI and trying to get an idea of what's going on. I would expect that to happen.
Sure.
We all do that to some degree on things that are not in our field. But when all the communication, you know, you can tell when it's by just a blatant ChatGPT cut and paste job. It's like that, and they're asking for all these things for you to do. It's like, no, I'm not going to do that. I mean, I'm already doing what I'm supposed to do, and you need to. This is not a relationship that I choose to have.
Right.
And so that's the type of client that you will spend so many hours and never satisfy that client. And I think that's what comes down to. Some of these clients will just never be satisfied, no matter how much you can, even if you move mountains for them.
And God forbid something goes wrong, even something relatively minor,
Yeah.
it'll be your fault, and they will quickly turn on you.
And nowadays, they'll turn on you and go to Google reviews and give you a 1-star review. And that it is very damaging in this highly competitive area we're in, obviously. So you don't want that. And so that's, I think we've pretty well covered, you know, that type of thing. But it's something you have to be disciplined on, because we all get to the point where our case list is lower than we want, and we start wondering, when's the next case going to come in the door? And when one comes in the door that you know you shouldn't take, but you could make something of it if you had to.
Right.
Just think about this. You're going to be living with that case for the next 5 years, perhaps. And it is never going to get better than it is that day. You know, it's just going to be
very rarely.
Very rarely. And it's going to be one of those things you might even take a fee at the end of the day just to be done with the client. So just always walk away from those if you can. And I say that having absolutely taken that client many times.
Yeah.
And so I'd like to say we're getting more disciplined about it. I think we're getting more disciplined about it, but it's hard to be perfect on it. So take the advice that we haven't always taken for ourselves.
Well, let's talk about another kind of case that maybe you shouldn't keep. And by this, I don't mean you should just reject it and get rid of it. What I mean is you should refer it out or bring someone else in on the case to help you with it.
Right.
One of those scenarios may be where a case seems very simple at first, and you embark on litigation, and it either suddenly or by degrees just expands in scope. For instance, a lot of commercial vehicle cases are no longer just the truck driver and his company. You now see more cases with potential broker liability. You have multiple layers of insurance. So you may think you've got a relatively simple truck wreck case, and you're going to have opposing counsel, and you show up at depositions one day, and you've got 4 lawyers in the room. Is that something you're ready and equipped to handle, or do you think, you might consider getting some extra help to come in and fight that battle for you?
And this isn't just good business sense, this is actually part of the ethical rules. The very first rule, Rule 1.1, discusses competence. And it says you must have the legal knowledge, skill, and thoroughness of preparation to handle whatever the matter is. But if you don't, you can achieve competence through association of competent counsel or referral. So it's a way to make sure you're complying with the bar rules. He's also studied, but when you get to something like that, this isn't an area where it's like, well, I'm gonna learn how to draft a simple will or something like that you can probably pick up within a book. It's something that is going to have layers of nuance that really should include someone else.
And it may not even be a competence thing, it may be, but it may be, one of our more recent medical malpractice cases, we've got, I think, 4 entities: anesthesia group, surgical group, orthopedic group, and I think 4 or 5 doctors.
Yeah.
And where there's 4 different defense firms, and just think of the number of experts. You got to figure each defendant's going to have 2 or 3.
Yeah.
And so we've associated another law firm that we like to work with to come in on that case with us. Not that we're not competent to handle a complex medical malpractice case, but it just makes more sense from a business standpoint to share the work, share the expense, share the risk.
Right. Well, one of the big cases that we talk about on here is our case at the U.S. Supreme Court. We have multiple firms involved in the litigation due to the size of it, but then we also, when we went to the Supreme Court, we got Supreme Court counsel involved because, could we have done that briefing? Yes. Would we have done it to the level and to the sophistication and to the degree it needed to be done for that court without people who specialize in it? It would have been a challenge.
Yeah.
I don't want to say no, but it would have been a challenge.
Nobody wants to say no.
Right.
But I'm telling you, they did a terrific job.
They did an amazing job. Yeah. It's and I think one more benefit to that is, we've talked about this before, is I love when we associate with other lawyers, whether people bring us in a case or whether we bring somebody else in a case, because everybody does it a little bit different, right?
Yeah.
And you can learn so much. Our practice has gotten better and better. I think over the last 5 or 6 years, I've seen a difference because of some of the firms we associated with, and we learned how they did things. And it wasn't 1 + 1 is 2, it was 1 + 1 is 3. We just started realizing, hey, let's incorporate this, and that just supercharges your practice in so many ways. And I gotta say, a lot of the people who refer us cases are really good lawyers. Mm-hmm. And I like working with the people who refer us cases because I learn stuff from them too.
Absolutely.
And certainly in other jurisdictions, when we get brought in, it's really interesting to see how other people work in their jurisdictions. And what of that could be transferable to what we do, because I've noticed every state, the lawyers practice a little bit differently, just their routines and kind of traditions and that sort of thing. And it leads to idiosyncrasies that may not be significant on a case, but it may lead to a little greater efficiency, just a nice way to do things. It just makes you a little better. And that's the way it goes for a while, is that incremental improvement.
Well, talking about the resources and sharing the risk and the burden of having to invest in these cases, time and money, it occurs to me, or I've long thought, that underinvestment in a case is one of the most common reasons that a case underperforms. So, when you've got a case that you legitimately feel can be a 7 or 8 figure case, you really need to be putting major resources into that case from the very beginning. And you got to ask yourself, am I developing this case in a way that is really maximizing the value of it? Mm-hmm. Or am I investing in this case and developing it in a way that's trying to reduce my exposure to it?
That's true.
And if you really feel like you need to be reducing that exposure, you need to bring somebody else along with you, or you need to look at it and say, well, if I'm worried about exposure that much, maybe this isn't as good a case as I thought it was.
That's a very good point. When you start thinking about your exposure with a case, take a minute and think about what's going on with this. Why am I feeling about that? Has the case gone south, or are you out of your league at this point? And that's okay. Everybody gets there, and to some way extent, we started getting some case that had nothing to do with what we're used to. We could quickly find ourselves out of our league. In fact, haven't done these before, but we don't have a lot of experience with class action lawsuits. And we have one that we're starting to pursue, and we're going to bring in some friends of ours who do it because they're very good at it, and they're better than we are at it. And so we want to work with them. So it's good to recognize where you are and when to bring in somebody else, whether you need to or whether it just be better for the client. So in this kind of situation, when do you see the time to start thinking about bringing someone else in? And I guess it sort of depends with each fact pattern.
Right.
What are your thoughts on that?
I mean, I think the general answer is the sooner the better, but that's not always reality. But, especially if you've identified it as a valuable case and you know that investing resources in it is going to improve that value, and you're worried about the cost and the complexity. And if you know that getting the case ready for trial is going to make it more valuable than getting it ready for settlement, if those factors are all on one side, and you know that sooner, then that's when you should bring somebody else in to help you, if that's a need. There are some cases that aren't going to be made that much more valuable by spending more and bringing more lawyers in. The most typical thing is when there's just limited insurance and nothing to go after over and above that insurance. So if there's $50,000 of insurance, that case is never going to be worth more than that.
Right.
Unless you get into a bad faith situation or something like that. But what we're really talking about are high value, complex cases. General answer, sooner rather than later. That's not always what happens.
And it all depends on where that inflection point is for each different firm, right?
Mm-hmm.
If you have a firm that, if you have a workers' comp firm and you have a PI case that comes in and it's a big case, you may not have the resources in place or have the day-to-day knowledge on how to work up that PI case, and you want to get somebody involved sooner rather than later. Same fact pattern with someone who does do personal injury, maybe not a trial lawyer, but works up cases, files cases, knows how to get experts, understands how to build the case, maybe does a few trials, but not 7-8 figure trials. Then you may want to just hold the case till the end and see if we'll work up the right way and get it resolved.
Right. I would expect that somebody in that scenario, they're going to work it up. They're going to make a demand, hopefully negotiate it, maybe attend mediation, and it's at the point where the case can't resolve.
Right.
That you need to bring somebody in. And I'll say this. Even before that, you can start having a conversation with somebody like ourselves or another lawyer that you may refer the case to, and just start getting their ideas on what needs to be done for prep in the event it doesn't settle.
I was going to bring up the same thing. I mean, that's something we do with folks. They call us up and say, we got this case. We're not ready to bring somebody in yet, but we'd like to run it by you. If you have a mentor, if you have a referral partner that you trust, they should be able to spend, ask them to spend a little time talking through the case, making sure that you have all your grounds covered. Because a lot of people are trying to get to the point where they can try 7-8 figure cases, and they want to have the experience doing it. They don't want to refer it out right away. But get some advice and some guidance on what you might need, and that will be very helpful, and make sure you're doing everything. And that way at the end of the case, if you say, okay, I want to bring in somebody to help try the case with me, it's already put together. You know that it's going to be, all the pieces are going to be in place.
Right. But, here's some of the things that we worry about sometimes when we get a late referral. Are there gaps in the evidence?
Sure.
Something that we would have really wanted to have run down and, but due to the passage of time or closing a discovery or what have you, we just can't go back and do that. So we've got gaps in evidence. Not necessarily a deal killer, but it makes things more difficult. Mm-hmm. The other one is locked in narratives. We may look at a case and have in our minds like, well, I'll tell you what, the theme of this case, it's X, Y, and Z, but the narrative's already been built because all the depositions have been taken, trial briefs have been written, what have you. So the story, the narrative is already locked in before we have a chance to shape it.
Motion practice.
Yep.
You know, if you're past a motions deadline, and especially with trial motions in limine, evidentiary motions, but we may have a creative motion that could lead to a large advantage that you don't necessarily otherwise have. We had that in one of our California cases early, and by the time we got in, the case had been bifurcated, and we said, well, let's move to unbifurcated. And they had never heard of such a thing in California, but we moved to unbifurcated. The judge said, you know what, I agree with you with these facts.
Yeah.
And it was unbifurcated, so.
Which made a huge difference in the case.
Huge
and
difference.
Caused the insurance company to recalculate their equation
Well, it went from
and
a
settle the case.
$25,000 offer to $1 million offer pretty much overnight after that. So, I mean, those are the type of things you don't want to wait too long. That's a very good point.
What other scenarios should prompt a lawyer to think about, you know, maybe I need to associate somebody else on this matter, or even just straight refer it out?
Well, one of them obviously is the financial considerations. I mean, a big case, especially a complicated case, I'm thinking medical malpractice, they're so expensive. And you have to be able to commit to putting in not just your hours, but also the money, and you can't do it on the cheap. If you try to do it on the cheap, you're just going to lose. Then you won't have the evidence you need, and then nobody's going to want to touch it.
Yeah.
So, I mean, I think having a realistic budget for a big case and sitting down and actually thinking it through. If I got all the experts I need, if I get all the animation at trial, all the things that cost money, how much is this case going to cost, and can I afford to do that? If you can't, then obviously you either need to figure out how to get the money to do it, or associate somebody who is used to dealing with big cases, who has the resources to put into it. So that's one thing.
Yeah. I'll tell you another thing, and this isn't so much referring it out. It is co-counseling with someone, but maybe on a lesser scale, is if you're out of your home venue,
Oh, yeah.
you really need to think about getting someone local on the ground that knows the judges, knows the court, knows the citizens that are going to be your jurors, you know, local counsel. And, you know, we certainly use local counsel when we're in different venues.
100%.
And, you know, we may not ask them to do any real work on the case, except for to be there for us to bounce those kinds of ideas or questions off of, and sit with us and pick in a jury. And, you know, it may be a 10% of the fee that we associate local counsel on, but they can be invaluable in their insight, knowledge of the jury pool, and the judges.
Absolutely. I also think the smaller the community, the more important that is. If you're going, you know, I say that the local counsel we had in Los Angeles last summer was crucial to our success in the case.
Right.
Because the court system is difficult to navigate for someone who's an outsider. And picking the jury was very helpful too. That said, if you're in, you know, Hayhira, Georgia, you need somebody local, because the people on the jury are going to know your client,
Right.
or the defendant, or the situation, and you need to know who these people actually are. Because that local counsel in a small community can really make a huge difference in your understanding of the jury, of the community, and the message you want to give.
Yeah.
And what's important to them, and so you don't look like just a pure outsider who's a dummy as they come in the courtroom.
And again, you know, some communities are limited on what lawyers they have there. Others are not. And, you know, sometimes you call up a friend and be like, hey man, I want you to be local counsel. And it's a lot of fun to work with your friends on cases like that.
Oh, totally.
And we serve as local counsel too. We
A lot of
have
times.
several firms that have contacted us and said, hey, you know, you want to be local counsel in this case? It's a great way to work with other lawyers. You don't necessarily have to give away a whole bunch of your fee, but it can be invaluable.
Yeah, and if you want to become local counsel, you know, a good way to get involved in that is get involved in some statewide organizations. And so if you're from a smaller community and the people in the big cities get to know who you are and they've got a case down your way, they're gonna call you. Or be very involved in the community if you're involved in, say, the city council of some small town or whatever. You're gonna be someone that people seek out as a respected member of the community or a member of the community that sort of knows the comings and goings of everybody.
So parting thought I want to leave with everybody is, referring your case out, even doing it early, it's not necessarily giving up control of your case. It's maximizing the value for your client. So anybody has any questions, feel free to contact us. Paul, what are you going to say?
Well, I would say one more thing. I mean, sometimes referring a case out, the value it adds, obviously more value for the client in these situations, but sometimes it will add the value of the fee, even with the referral fee in place. So that if you can, double the value of your case, then it's economically beneficial for everybody involved. So that happens a lot more than people realize.
Paul, I've been playing a lot of tennis lately. The last few years I've really gotten into tennis.
Yeah.
I've invented a new game.
What is it, Andrew?
It's called quiet tennis. It's just like tennis without the racket.
Well, on that note, we're going to push you out of your misery here and call it the end of another episode of Justice for Y'all. We'll see you next time.
Thanks for listening to Justice for Y'all. If today's episode resonated with you or if you find yourself needing legal guidance, remember, we're just a call away. You don't have to work through the difficulties of your situation alone. Visit our website at bowenpainter.com, that's BOWENPAINTER.com, or give us a call at 912-335-1909. We're here to serve you with the dedication and warmth only true Southern hospitality can offer. Thanks for tuning in, and don't forget to subscribe to our podcast on your favorite platform so you don't miss an episode. And tell your friends and family about us if they're ever in need of some legal insight. Take care, and remember that we're committed to justice for y'all.